We're still working our way through the C's in the ABCs of environmental law. And today, C stands for an important term that you might see in a news headline about pollution, and that is the consent decree. Now, it does sound like dry lawyer speak, but it is a big deal. Essentially, a consent decree is a settlement, usually between the government and a private entity, someone who has been alleged to have broken environmental laws. But a consent decree can also be a settlement between private parties as well. It goes beyond a typical settlement because it's not just a contract between the parties. It's an actual court order. The parties file the agreement with the court, and a federal judge will sign off on it and keep the case open until all the requirements are met. So you can also think of it as a cleanup roadmap or a compliance roadmap with a hammer over the settling party's head. Because when a company or a person enters a consent decree, they are usually agreeing to do three major things. So there's usually a civil penalty for what they did wrong. They also have to engage in some sort of actions, like installing specific technology or changing their operations to either stop the polluting activity or help prevent something from happening in the future. And the third is that there are going to be very strict enforceable deadlines for things like the compliance, the inspections, and the payment of penalties. This makes it more serious than just your usual settlement, and it's more likely that people will be held accountable. Because if a company misses a deadline in a regular agreement, it just gives the other party a right to potentially sue them or go complaining to court. But if they miss a deadline in a consent decree, they're basically in contempt of court, which means the judge can impose harsh penalties. Most importantly, sometimes these deals have a public comment period. So that is a window for anyone to go tell the court if you think a settlement is fair for your community or for your client, if it's going to impact you. Because once a consent decree is in place, it isn't just a contract that gets easily modified. It is a binding court order, and there are going to be more difficult steps to change it, so it's the law of the land. If you don't comment on it right away when you are notified about a public notice opportunity, it may be too late later to change anything about it. And if you're the party who's subject to a consent decree, compliance is key. Understanding your deadlines, your requirements, and making sure you are telling everyone who may have responsibility for your operations exactly what the requirements are to avoid the potential penalties or running afoul of a court later on.